If someone you care about has been arrested in the federal system, here's what you need to know. The person is going to be taken by federal agents to a federal magistrate. Initially, when the person is arrested, other than law enforcement telling you where the person's going, you're not going to be able to look up or call a local jail or holding facility to find out where this person is. Generally, agents will tell you the person's being arrested and they're going to be taken in front of a magistrate. The magistrate at this initial appearance is going to inform the person what the charge is against them. And the judge at that point will generally detain or hold the person for a preliminary hearing. The preliminary hearing is a hearing where the judge takes up several matters, including whether or not this is the individual who is actually suspected of committing the offense. So did they get identity right? Whether there's probable cause to hold the person. Are there specific articulable facts that indicate this person has committed an offense? And finally, detention. The government has the ability to ask for a 3-day continuance. The defense has an opportunity to ask for a 5-day continuance. You need to go into the detention hearing prepared to put on your best case to ask the judge for release. In the federal system, it's generally not a question of setting a monetary bond. Certainly in the Northern District of Texas, a monetary bond doesn't even come up. Instead, where the judge is focusing his or her attention is on several factors, including whether or not this person's going to come back to court when they're ordered to come back. Is there a likelihood they're going to continue to commit offenses? Are they a danger to the public or even themselves? As you're thinking about witnesses that you want to put on the stand for the detention hearing, you're thinking about individuals who can talk to the judge about those factors. So they need to be able to talk to the judge about your ties to the community, whether you work here, live here, go to church here, have coworkers that can testify for you, other people from the community or your family or friends who can tell the judge the person charged with the offense understands what they're charged with. They're going to come to court when they're asked to come to court, and they're going to stay out of trouble. I'm going to keep an eye on them to make sure they're walking the straight and narrow, keeping their nose clean, that they're not doing anything they're not supposed to do, and going above and beyond that, that they are willing to abide by any conditions the judge imposes. On a drug case, that might be going to a drug class, providing UAs to show that they're clean. It might mean, on some cases, agreeing to wear a GPS monitor so the judge knows where you are at all times, and probation, who will be supervising you, knows where you are at all times. You need to be able to think outside of the box, but come up with a plan that tells the judge, here's how you know this person's going to show back up for court and stay out of trouble. Also understand there are some cases where there's a presumption against release. So in cases where the possible punishment begins at 10 years, so it's 10 years or greater, or the person is charged with certain offenses like drug trafficking, the presumption against release means the default position of the judge is, I am not releasing this person back into the community. That is a rebuttable presumption, meaning the evidence you put on might be strong enough to change the judge's mind, even though the starting position is, I'm not going to release this person. And we have certainly been able to secure release of individuals even when the presumption was against us. The judge is going to take into consideration the strength of the case, the person's criminal history, their ties to the community, and the other factors that we discussed. And if in totality the judge believes this person can follow the rules, stay out of trouble, show up when they're supposed to, then you'll have an opportunity to get them out. There is nothing worse than getting someone out on a preliminary hearing and that person then committing further offenses or coming back positive on drug tests. So if you're trying to help someone with a drug addiction, they have to be certain that they're committed to walking the straight and narrow, because if the addiction gets the better of them after they're released, they're potentially looking at a greater charge, and they're certainly looking at the judge taking away acceptance of responsibility. Certainly in the Northern District of Texas, judges look at continued offenses, even offenses related to continued drug use, as a person not fully taking responsibility for their actions. So in a scenario where you were considering entering a plea ultimately to the charges, but you have messed up, you're unlikely to get that acceptance of responsibility because your actions betrayed how the judge believes you truly felt about taking acceptance. ultimately, you want to put your best case on for detention, because once the judge has heard the issue of detention, the judge will not reopen that issue unless there's something that has substantially changed or was not brought to the court's attention at the initial detention hearing. So only when you have that type of changed circumstance or new evidence will the judge even consider addressing detention. Otherwise, if you've been detained, you're likely going to stay in custody until, at the very least, the case is resolved. I hope you found this video to be helpful. We're putting up these videos in response to questions that we are receiving, so if you have a question that you'd like for me to answer, just pop a comment below.